Welcome to Estate Planning Beyond the Binder.
Hello and welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trusts and a leading estate planning attorney serving Orange County families for over 25 years. My name is Kevin Rosenquist, and in today's episode, we're separating fact from fiction and breaking down some of the biggest myths Brian hears all the time about estate planning. Brian, welcome back.
Thank you, Kevin. Thank you for having me on today.
Are you excited to talk about all the things that you hear that you want to debunk today?
As I always tell people, the most dangerous thing my clients do is they read stuff on the internet.
Or today's world, it's even worse because it's ChatGPT, right?
Yeah, I mean, there's a lot of stuff floating out there, and we're having that's first thing is I want to make sure my clients are making decisions based on fact, not urban myth.
Absolutely. All right. Well, let's start with this. What's the biggest estate planning myth that you hear over and over again? Or if you got a couple, that's fine too.
Is that if something happens to me, the government's getting my money. And that's potentially true. It's not that they're getting it. It's just they would hold it. We see this happen all the time, actually, is, people actually, I have money in a bank account that went dormant. It got turned over to the state. I got to go get it. And I can go get it. It's not a problem. I can go get it. Or if I died, my family could go get it. But that's obviously not the good way. We don't want that to happen. We don't want the government to get to be holding money for us because, we didn't do the right thing. And so, we want to create an estate plan and then make sure logistically everybody knows about our assets so that things don't end up going to the government because no one's claiming it. And that's actually, I guess, if that's the myth, maybe it's even that doing an estate plan, and that's why it's, we call it estate planning beyond the binder, is doing an estate plan by itself does not make sure everything goes to your family. Okay. It makes it more likely, obviously, but one of the key is logistically, that's as important part of all the planning process as much as the legal part. I always tell people, my job is to get people to your desk. They're at your desk. They're now in charge. In charge of what? That's your job. Okay. Your job is to make sure they know what you have. Because as an example, if you have bank accounts and you die, even if the banks know you died, the banks don't raise their hand and say, hey, we got money, come get it. Okay. They're waiting for somebody to come to them and claim it. And so even if I have an estate plan, even if I did everything I was supposed to do in terms of funding the estate plan by making the trust the owner or beneficiary of the asset, if I don't tell my children or whoever's going to be in charge of the trust on my behalf about those assets, that's a bigger problem. Okay. If they can't find it, because especially nowadays, people have got money on online banks, worse yet, cryptocurrency. Sure. There's all kinds of things where it's not obvious. There's no list. There is no master list you can go to that somebody else has created that they can go find your money. You could be 1,000 different banks nowadays. All right. And so I guess if, the number one myth is even, having an estate plan is that doesn't guarantee that all your assets go to your kids because they have to know about it. And that's the practical side of things. And that's what we try to emphasize with our clients is there's the legal side, which we try to take care of. And there's the practical side, which we encourage you to take care of. And we give you checklists, templates, and so on, how to do that. But, that's probably, I would say the biggest myth is even the people that do the planning is they're not keeping their plan up to date in terms of not so much the legal side, the practical side, making sure that whoever is in charge knows about all the money, where it can be found. They don't have to know how much is there. They just need to know what banks to go to and then what bills to pay. Mm-hmm. And then, because that's what makes it easy for people. It's not, having the plan is step one, but step two is the logistics.
One of the things that I think that a lot of people misunderstand, and I admit before I talked to people like you, I felt the same way. And that is that trusts are sort of viewed as something for people with a lot of money, a lot of assets, a lot of wealth. But that's not true, is it?
Yeah, no, definitely. I mean, usually, there's two stages here. There's estate planning in general. Okay, estate planning, people think estate planning, think I have a lot of money and stuff like that.
Yeah, and well, it's the word estate, probably, right? Yeah. Some people are like, I don't have an estate. I just got this little house,
Well, let's forget. Let's say you have no assets. Like my children, when they turn 18, I'm going to create an estate plan for them. Not so much because I'm worried about their money. I'm worried about who's in charge of them.
Right.
Okay. Who's in charge of making financial decisions for them, and more importantly, medical. Because the minute my kids turn 18, my ability to get medical information about them is cut off. HIPAA says doctors and the hospitals are not allowed to release information to me about my children, or to anybody without written permission. All right, and so that's step one. Estate planning is about making sure somebody's, and that's the issue. People think about the money. Yeah, that's part of estate planning, obviously. But ultimately, I always tell people estate planning first is about who's in charge when you can't be. And again, as soon as you're adult, that means somebody else. If you can't be in charge, you need to give somebody authority to act. And there is no automatic. It's not your spouse necessarily. It's not your parents, siblings, whoever it is. It's not necessarily automatic who would be in charge. And so I guess in that sense, that's one myth. Even your spouse, in theory, they don't have access to your medical information, as an example. Okay, so that's step one. Who's in charge when you can't be, whether it be your spouse, your parents, your siblings, whoever it is, your kids one day. You want to make sure somebody has authority to do that. So that has nothing to do about money. Okay, that's who's in charge. Now, the other part is most of my clients, again, definition of wealthy is everybody different, but they have some assets, whether it be just strictly financial assets and or they own real estate. Okay, but I always tell people the first time most people will do an estate plan, A, would be potentially is when you get married, or B, again, if you're not married, it's because you want to make sure somebody's in charge. But B, you have kids. That's probably the number one reason why people need an estate plan is because who's in charge of the kids? That's probably the single most important decision we're going to make. Is at the end of the day, if something happens to me and my wife, the money's going to the kids.
Right. Yeah.
Okay. One way or the other. Okay. But who's taking care of them? Who do we want to be the potential guardian? We want to have a say, because if we have no estate plan, nobody's in charge. We have no input at that point, because a judge is going to decide between the people who apply to be the guardian of our kids, who to choose. And if we don't have something like a will, which nominates a backup guardian for our kids, there is no word from us. They'll just go on whatever information they have based on what somebody else is telling them, and they'll have no input from us as the parents as far as who do we want to be the guardian of the kids. I don't know if it's so much a myth. People think things are just going to happen automatically. If something happens to them, it's not automatic.
Right.
And that's why being wealthy, again, anybody cares who's going to take care of their kids, no matter how much wealth you have. And so you want to have something in place that says, this is why I want to be the guardian of my kids, so that a judge can take that under heavy consideration if something happens to you. But again, and then beyond that, if you own a home in California, with our housing prices here, probate is very expensive. It's easily going to run in the tens of thousands of dollars and take 1 to 2 years, and people want to avoid that. And the best way to avoid that is by typically having a revocable living trust and have the revocable trust own the house.
I feel like a lot of people think, oh, I have a will, that's all I need. Do you run into that a lot? And is that true in some cases, or is that widely a myth?
So having a will, the ironic thing is I do probably 99% revocable trust. I've probably done less than 30 in my 17-year career now. I've probably done less than 20, maybe 20 or 30 standalone wills amongst my thousands of clients. And that's because, ironically, a will, it is effective ultimately. Okay, if I just had a will and I have I have a son, and if something happens to me, and and I say in the will everything, my son gets everything, great. Okay, he's going to get everything, and I'm going to put an executor in charge, because a will and the trust are very similar. They say who's in charge of where everything goes. Okay, the problem is a will cannot transfer control of assets from me to someone else without them having to go to court typically. Okay, so if a house in my name in a trust owns it, the transfer control goes from me to my successor trustee. No one has to go to court. They just file paperwork. But if I just have a will, the property's in my name. In order for them to gain control of the property, they're going to have to go to court, which is called probate. Okay. And so, and that's why people come to us. They don't want their family to have to go through probate because it's long and expensive. So a will, again, it can work. It's potentially going to go to court, especially and then if I have minor children, there's two options. A, I name my kids as beneficiaries, in which case if they're under 18, it's going to probate because they have to decide who's in charge of the money. Or B, if I actually wanted to go through my will, I don't name any beneficiaries, then the money goes to my estate, in which case it goes to probate. The ironic thing is the times that people can avoid probate, they may have a will, but because they don't own real estate, so if there's no real estate, there's no probate. They have financial accounts, which is your primary asset, and then they name beneficiaries on those accounts. The will has nothing to do.
Right.
Because those assets go directly from that. That person goes to the bank and say, I'm a beneficiary under the bank account. Give me my money. It has nothing to do with the will at that point. So ironically, when I do a will for somebody, we're telling them, for the most part, unless you are planning on things going to probate, which a handful of clients, maybe a small, tiny percentage, that might actually be a good idea because maybe we do want the judge to serve as a referee. But for the vast, 99% of us, we don't need the judge to serve as a referee. Okay. We don't want things going to court. But ironically, those people I do a will for, most of them, I'm telling them, at best, personal property is going through the will. Because if you designate beneficiaries to avoid on these accounts to avoid probate, that avoids probate. And so the will is actually not doing anything. That's why we do end up doing so few standalone wills, because the will technically, other than maybe, again, if you have minor children, want to appoint a guardian, if that's your primary goal, then yeah, you need a will at the very least. But that's also why when we do a trust, we also have the will as a backup. And that's where you're going to name backup guardians for the kids.
Okay. Yeah. Part of the full estate plan picture. Yeah.
Yes.
Is there ever a situation where just writing something down, having it notarized or something, is that ever valid?
So in California, and again, I can't comment on other states. In California, you have two options for what we call a testamentary document, or a will in this case. You can, the will is typed essentially, and you sign it, and you have two witnesses. So it can't even be, I have people like, can I notarize a will? You cannot notarize a will. It must be signed by two witnesses. You have to sign it in front of two witnesses who are not party to the document, and so they can't be related to you or named in the document in any way. Okay, so you need two witnesses, or you can do a handwritten will. So a handwritten will as long as as long as a judge can interpret, because obviously a will, in order to transfer it, has to go to court. As long as a judge can interpret your intention, yes, you can do a will as long as it's in your handwriting and signed by you. Don't need witnesses or anything like that. It just needs to be in your handwriting. It's called a holographic will. But I don't deal with that much. But in theory, it can work. But obviously, it's kind of like going to WebMD and try to diagnose yourself. Even if you do a will on your own. I mean, 80% of the time you might be fine. Holographic will probably do less. But I'm worried about that 10 or 20% of the time you're not right. It's not done correctly. And now there's issues.
Yeah, I wanted to ask you, actually, that was one of the things I wanted to check on, is the online services, that a lot of people do. Obviously, there's a few different ones out there where you can just do it yourself. What's your experience been when people do that? And you see them, do they have to come to you to get things fixed? Do you see them not work? What is your view on that? When
you do it yourself, there's nothing inherently wrong with the document itself. Okay, usually the document, per your wishes, is done at your instruction. The problem is when you do it yourself, you're not getting any kind of legal advice. Okay, they can't give. They're not allowed. In fact, they flatly say, we're not a law firm. We are order takers. You give us you tell us what you want, and we'll draft a document based on what you want.
Right.
Okay. But we cannot give you any personal advice. As much as I'm concerned, as these attorneys, we're interested in how AI might take over one day. Okay. One thing I can say is AI cannot give advice.
Right.
Okay. At least not specific advice, given your situation. It cannot deal with family dynamics. And again, so you're doing a document at your direction, and that's the difference. You're not getting legal advice. Nobody's trying to understand your goals, your concerns, and give you options. They just have you fill out a form, and they spit out a document, and it is what it is. And again, maybe it's fine. And sometimes, we produce a document, and effectively it may say exactly the same thing, but at least you got legal advice. And then our document, the other issue is, the average, trust done, online is probably 7, 8 pages. Our average trust is about 30. And again, not that longer is better, not that bigger is necessarily better, but it's definitely more comprehensive.
I was just going to say, it obviously it's going to cover more. That's for sure.
I mean, the basics may not be that different, but the what ifs are going to be covered.
Right.
What if there's a drug or alcohol problem? What if there's a disability and a special needs trust is needed? A good comprehensive document is going to have provisions for that. That's going to accommodate things that, again, probably won't happen. But if it did, there's a plan. And then also, as we talk about the comprehensiveness in terms of thinking things through. Mm-hmm. Okay. We try to think things through at 2 or 3 different levels. What happens if plan A happens? That's fine. And that's most documents will do fine with plan A. But what's plan B and C? And have you thought through plans B and C? And that's my job, is to help you think through. I assume everybody dies. I assume people can be born. Okay. My document can address either issue automatically without necessarily having to do anything, because it's already in there. But, the documents done online ones, they typically aren't going to address, they may not address those very well, just because they're just not designed to do that. And then finally, the logistics. You're not getting any ongoing, you're not really getting much support from them. Yeah, you might get an email every now and then, but that's where the ability to talk to somebody without, that somebody who's familiar with your document, right away, and so that your plan can be effective. that's really the difference between, working with a law firm and then most importantly, working with a firm that can respond to your questions so you've got enough people to respond to you in a timely fashion is so important so that your plan continues to be effective. And so that's a lot of times the issue with the online ones is, your trust, we find that those trusts become out of sight, out of mind pretty quick. And nobody's paying attention.
For anyone listening who's listening to all these and going, wow, I really need an estate plan, I haven't done this yet, what would you say is the best first step to kick things off?
I always tell people, first of all, I always look at the issue of why they aren't doing it in the first place. Usually it's because they think it's complicated. And for most people, it's not, in the sense of, I always tell people, when I talk to my clients, I need answers to 3 questions. Who do you love? Who do you trust? And how much do you trust them? Mm-hmm. Okay, if you're married, that starts with your spouse. It goes to your kids, your siblings, your parents, whoever it is that's going to be involved in these documents, friends. Those are the answers to the questions I need to get an estate plan done. Okay, I don't need to know a lot about your assets. I don't need a list of all your financial. People think I got to list out all my personal property. I got to list out all my accounts. I don't need that information. We'll talk about those things, but I don't need that information to get an estate plan done. Okay, I need to know presumably what real estate you have. What real estate you own. But I don't need to know a lot of those.
Ideally, yeah.
Ideally, I have a handful of clients that, wow, you couldn't remember all your property. That's a problem I wish I had. But
yeah,
right. Most of us don't have that problem.
Right.
And so it's usually people usually when they finish with it, they said that was much easier than I thought.
Yeah.
Again, part of my job as a firm is to make it simple. And, and the reason why people come back, refer clients to us, their friends and family to us, because we made it simple for them. Mm-hmm. And when they finished, they said, wow, that was a lot easier. I wish I'd done this a lot sooner.
Absolutely.
And again, I always tell people, unlike, having an estate plan is like having insurance. It's like having car. It's hopefully you're not going to need it anytime soon.
Right.
Okay. But unlike car insurance and not having a plan is like driving without car insurance. As long as you don't get in an accident, it's not a problem. Right. And in theory, if you come home that day in an accident, in theory, you save money by not having to pay for the insurance. Okay. With an estate plan, you're not saving money. Okay. Mm-hmm. Yes, you might have to update it one day, but you're not saving money by not having it. And for better or worse, it's not like estate planning. In theory, it's, if you're working with an attorney, it's not gotten cheaper over the years.
Right.
Okay.
Right.
It may have some other options now with the internet, but it's not getting cheaper over the years. So you're not saving money on that point. And I always tell people, your plan's doesn't have to be perfect. You don't have, every decision you make can be changed. It's better having some decisions down on paper is better than having no decisions.
Right. Yeah.
Something's better than nothing. And that's what I tell my clients. And even tell them, if we're not for you and, or you don't want to get something done, whether we're doing it or you do something else, that's something's better than nothing. Obviously, I recommend talking to someone like myself to get it done. So you make sure you get it done right. And, that's usually the issue with people that, do it online is, 5 or 10 years, 5 years later, they start to worry, did I really address all the issues to be addressed?
Yeah. Did I do it right? Sure.
Yeah.
Sure.
Did I do it right? And then they come to us and then we'll talk about it.
All right. Well, that's it for today. Estate planning myths are everywhere, as we talked about, and they can definitely cost your family real money, real stress, also missed opportunities. So if you're ready to make a clear, personalized plan that actually works, visit ocwillsandtrusts.com or call to schedule time with Brian and his team. Also, don't forget to subscribe, like our videos. We really very much appreciate that. Brian, as always, awesome to talk to you. Thanks so much.
All right. Thank you, Kevin. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.